So, good afternoon and welcome. If you don't know me, my name is Tom Hughes and I'm a Senior Market Services Executive at the IUA, and I'll be chairing our webinar this afternoon. So, of course, thank you all very much for taking the time out of your schedules to join us this afternoon. This is our US Medicare training that we've been providing on a pretty regular basis at the moment. So before we get started, I have a couple of quick pieces of housekeeping. We will be recording the session, which you may already have noticed, and we'll be making available a link to that recording alongside the presentation slides after the session. Do give us a few days because we just need to pull those together and get some approval, and then that will be issued by the IUA's events manager, Deborah Finch. You've probably also spotted that we have a Q&A function within the platform. We'd encourage you to make full use of that platform. We want this to be as interactive a session as our webinar facility allows it to be. Alison is very happy to take questions during the session, so I can put those to her at any point. So that actually turning to the session itself, we are very pleased to again be joined by our expert trainer, Alison Surcouf. Alison is a partner at Condon and Forsyth LLP. We're also joined by the chair of the IUA's Aviation Claims Committee, Fiona Hodgson-Wood, who is an executive loss adjuster of aviation claims at Chubb. So at this session, the type of thing that you'll be expecting to learn, we'll be looking at Section 111 obligations, who must report, when to report, and what must be reported. They are the key features of the session. We'll then hear a little bit about a very exciting and pretty recent announcement that we received from the CMS that follows some extensive lobbying between ourselves at IUA and Alison at Condon and Forsyth. So I think with that should be all of the housekeeping, and I'll pass over to Alison with our thanks to get us started.
Thanks very much, Tom, and thanks to the IUA and Deborah for having me and for facilitating. And thanks everyone for joining and for giving me the opportunity to speak to you today. I'm going to go ahead and turn my video off now, just so we can concentrate on the slides, and then we'll turn it back on during the Q&A section. So as Tom said, my name is Alison Surcouf, and I'm a partner at Condon and Forsyth in New York. We're a boutique firm that specializes in aviation defense litigation. I focus primarily on airline liability. Information about the firm and its expertise in representing domestic and foreign airlines is on our website and is included in the presentation materials, which will be provided to you. So I'll largely skip over that aspect of the presentation. This is a representative list of some of the major losses we've handled in recent times. But I'll just say that as an aviation defense practitioner, I also have extensive background advising aviation insurers on how to appropriately comply with the Medicare reporting laws since their enactment. So the topic at hand, the Medicare reporting obligations, as Tom had said, are found in a US federal law called Section 111, which requires a liability insurer to report payment of a claim with a Medicare beneficiary if that payment is reasonably related to medical care. So why does the federal government want you to report those claims? Because it doesn't want to pay for services, namely Medicare costs, if someone else is responsible for those same costs. And this is why you should really care. Because if Medicare does pay for medical care for which you as a liability insurer are responsible and it's not reimbursed, then Medicare can come after you for double damages. That's the lien times 2, and that's even if you've already paid the settlement. So Medicare is heavily invested in incentivizing the insurance market to comply with Section 111. And what better way to do that than with fines? The fines for non-compliance with Section 111 are substantial. They are generally $1,000 per day per claim of non-compliance, with a limit of $365,000 a year. The bottom line here is that Medicare is a very underfunded government program, and the insurance market is a more reliable payer than the individual Medicare beneficiary. So first, we're going to go through some background on the Medicare program, which will help to place Section 111 into context. And then we're going to go through the specific reporting requirements and best practices in handling personal injury claims. And finally, we'll discuss the circumstances where you might see Section 111 fines assessed. So first, the Medicare overview, including who is eligible for the Medicare program and the Medicare Secondary Payer Act, a law that you may not be familiar with and which is distinct from Section 111, but that I hope is on the forefront of your mind in handling US claims after this presentation is over. So Medicare is the health insurance program provided by the US federal government and is administered by the Centers for Medicare and Medicaid Services, or CMS, to persons who are 65 or older, as well as persons with certain disabilities. I just want to make a note that when we talk about CMS, the administrative agency, we also call CMS Medicare. So Medicare is the program of health insurance, but is also the word we use to refer to the administrative agency itself, which, as I said, is otherwise known as CMS. So the reason it's important to understand the fact that Medicare also applies to people with certain disabilities is that you cannot assume your plaintiff or your claimant is Medicare eligible just because she's in her 20s, for example. Medicare is provided either directly by the federal government or through what is called a Medicare Advantage plan, offered through a private health insurer who partners with the government to provide Medicare coverage, usually and then some, in return for a per capita fee from CMS or Medicare. Well, we're going to talk about Medicare Advantage plans and why you should care about them in just a minute, but I'll just note that they are a part of how Medicare is administered. So for background, the original vision for Medicare was that it would be the entity responsible for covered medical care, even if another private insurance company would have otherwise also been responsible for that same care. And this was the vision until it got very expensive. So in 1980, the US Congress enacted the Medicare Secondary Payer Act and made Medicare a secondary payer, meaning secondary to any other entity. So for example, in my line of work, if a passenger on an airplane is scalded with hot tea during turbulence, and upon landing, she's rushed to the emergency room, presents her Medicare health insurance card to receive care, and Medicare indeed pays for that care. When she gets home from the hospital, she sees a commercial for a personal injury lawyer. She dials a 1-800 number, and several months later, a settlement is reached with the airline for damages arising out of her burns. Well, Medicare wants its cut of the settlement for the hospital treatment it paid for. But how would Medicare know that our passenger brought a claim against the airline in the first place, or that a settlement was reached? Up until Section 111 was enacted, Medicare relied largely upon the beneficiary herself to notify Medicare that a primary payment was out there, meaning that a liability insurance payment had been made or is going to be made. As you can imagine, this was not the most effective way for Medicare to get repaid, as our passenger has a disincentive. She would, of course, rather get her free medical care and settlement. So Congress enacted Section 111, which essentially shifts the burden for notifying Medicare about the existence of a liability payment to the insurance industry. And having an appreciation for what incentivizes people, Congress attached substantial penalties to Section 111 noncompliance. As previously stated, they're $1,000 per day per claim. So I want to go through a particular case because I think it's an important cautionary tale, which really highlights why the liability insurance market needs to really pay attention to the Medicare Secondary Payer Act, in addition to Section 111. The case is out of the 11th Circuit, which is an appellate court that handles appeals from, among other places, Florida, and it's from 2016. So in 2009, a woman who was enrolled with a Medicare Advantage plan was injured on the premises of a condominium in Florida. Her Medicare Advantage plan paid approximately $20,000 in medical costs. Shortly after the incident, the woman and her husband filed a lawsuit against the condominium in Florida State Court. About a year later, in light of a pending settlement against the condominium, the Medicare Advantage plan issued a notice to the woman of its right to reimbursement for the approximately $20,000 it paid for medical costs, also called conditional payments. That is conditional upon reimbursement by the primary payer. Shortly thereafter, a settlement was agreed, and in return for $115,000, the couple released the condominium and its liability insurer, representing that there was no Medicare or other lien or right to subrogation. Subsequently, the condominium became aware of the medical lien and, not yet having dispersed settlement funds, attempted to make the plan, the Medicare Advantage plan, a payee on the settlement check along with the couple. But the couple refused. That was not a part of the terms of the general release, and the the condominium really had no basis to require it of the couple. Instead, the parties agreed that the funds would be dispersed directly to the couple and that their attorney would hold the amount in dispute, in other words, the $20,000 in dispute, in a trust fund. And so the remaining amount would be dispersed to the couple. Having failed to secure reimbursement from the couple, the Medicare Advantage plan sued the liability insurer for the lien ×2 under the Medicare Secondary Payer Act. And the 11th Circuit held that the liability insurer indeed had to pay. So in that case, the liability insurer paid this couple's medical expenses 3 times over, once to the couple as part of the settlement, and then twice to Medicare. And the reason I highlight here that this case dealt with the plaintiff's Medicare Advantage plan and not Medicare directly is that it may not be obvious to you or your defense counsel that the private insurance company that paid for the plaintiff's medical expenses was actually covered by the Medicare program. And in fact, that's exactly what the liability insurer in this case argued, that it didn't know Medicare was involved. But the court was unconvinced and held the liability insurer with constructive knowledge. So although we're here to discuss the Section 111 reporting requirements, we need to maintain a broader scope of the market's liability when Medicare is involved. So what exactly are the Section 111 reporting requirements? As Tom had said, essentially this breaks down into the events that trigger reporting, who must report, and what must be reported. And before we go into that, I want to give some background on the authority by which we as lawyers and the market are interpreting Section 111. So Section 111 is a statute in the US Code, and it's a very bare bones statute. It's called like an implementing statute. So it gives CMS the authority to develop regulations and implement the Section 111 program how it sees fit given its expertise. Because CMS has not yet enacted formal regulations in the US Code of Federal Regulations, an issue we're going to discuss later on, the authority by which we interpret Section 111 for now is a user guide published by CMS and CMS's own guidance. And that guidance can be very informal, including town hall conferences or sometimes written alerts that are published on their website. But while we wait for federal regulations to be formally enacted, we're really reliant upon CMS's own policy guidance and how it shares that with the market. So now we're going to go through when reporting is triggered. Again, a primary payer must report resolution of a claim with the Medicare beneficiary that is reasonably related to medical care. So we're going to break down this sentence into some chunks bit by bit. First, report. Section 111 reporting is done through an electronic portal established by CMS and is most typically administered on behalf of an insurer by an outside vendor. Reporting is not done on a claim-by-claim basis. Rather, each insurer reports quarterly on a timeline that is assigned by CMS, which is not necessarily in sync with the calendar year. Next, what does resolution mean? Resolution is when an obligation to pay arises. It is when this obligation takes effect that the Section 111 report is actually submitted through the electronic portal. Okay, this is kind of a mouthful, but the report is due in the quarterly report that follows a 45-day grace period after the obligation arises. So let's take this in the settlement context. A settlement is reached in principle, plaintiff signs a general release, and she dates it. It is on that date that the obligation to pay arises. So from that date, you then have a 45-day grace period. And then the next quarterly report that the insurer would submit is when the applicable Section 111 report is actually due. If court approval is required of the settlement release, then the obligation to report is triggered when the settlement is so ordered. I'll also note that payment means vouchers and other risk management tools. So for example, in the aviation context, a voucher for future travel, all other requirements being met, does trigger the obligation to report. Next, reasonably related to medical care. This includes mental anguish damages, even if the underlying claim is for property loss. So if a passenger makes a claim for lost baggage and in an effort to aggrandize the value of that claim, she includes as part of it the emotional trauma associated with the loss of her baggage, then that does trigger a Section 111 report. If the claim relates to medical care, the duty is triggered, regardless of how the settlement is structured. So in other words, designating the entirety of the settlement as being in compensation for pain and suffering as opposed to medical costs does not obviate the duty to report. Medicare is very specific, and I quote, "It's not up to the insurer to decide whether or not we have an actual recovery claim." A circumstance that also triggers reporting that may not be obvious is a wrongful death action. If the decedent is a Medicare beneficiary, then the Section 111 report should be submitted. There are also threshold amounts. So each year, Medicare makes an analysis about what amount of conditional payments is worth pursuing, given the resources spent by Medicare on attempting to recoup the conditional payments. That amount has held at $750 for the past several years. But in other words, if you settle a case for $600, then that's within the threshold amount and you don't have to worry about Section 111 at all. Now we're going to get into who Section 111 applies to. Otherwise known as a responsible reporting entity or an RRE. As a liability insurer, if you underwrite the risks associated with personal injury claims, then Section 111 applies to you. Self-insurance, to the extent that a business has not purchased liability insurance coverage, is also a responsible reporting entity. And by the way, this also includes responsibility for deductibles. This is a more detailed definition of who is a responsible reporting entity as a liability insurer. And the thing I want to highlight here is Medicare is interested in whether you have assumed an obligation to compensate personal injury claims under the insurance contract. And that's regardless if you have claims handling responsibility. But there are circumstances in which more than one liability insurer assumes an obligation to pay on the same claim. So there are exceptions, and we're going to look through some of those. The first is deductibles, which I just mentioned a moment ago. So in this circumstance, Medicare does not want duplicative reporting. If the settlement is in excess of the deductible and the insurer must report, then only the insurer reports. And the insurer reports the total settlement, including the deductible amount. And this is true even if the insured makes its payments pursuant to the deductible directly to the plaintiff. But if the insured makes its payment without recourse to the insurance contract altogether, then the insured reports and only the insured reports. The next circumstance that we're going to look at for an exception is subscription policies. And this is something that we'll discuss in more detail later on, and Fiona will take up most of this topic. But on January 10th, 2023, CMS confirmed by email that all subscription policies are able to rely upon the lead insurer to report on behalf of the following market on a policy. Previously, Lloyd's had obtained a special dispensation from CMS for lead-only reporting on behalf of the Lloyd's following market. based upon its specific regulatory and underwriting requirements. But CMS has now extended that exception to all subscription policies. And as I said, this uphill battle and the victory that ensued, specifically waged by the IUA, is something that Fiona is going to discuss in more detail shortly. But I just want to point out something that I had mentioned earlier, which was that, you know, before we see final regulations enacted, what we rely upon is CMS guidance, and that can come formally in the user guide, and it also comes informally by way of, for example, this email. And this is something that the market can rely upon. As a matter of administrative law, it's something that I, as a lawyer, would be able to cite to before a court. And it is something that we would expect to see incorporated in the next user guide. But as a general matter, while we're waiting for Medicare to go from, you know, the current user guide to maybe an updated one, we do rely on informal guidance from an administrative agency. Okay, the next example is excess insurance. And Medicare calls all types of insurance beyond a certain limit excess insurance. So this is sort of a large term here, but the general rule is that if the insurer payment reimburses the injured claimant, then the insurer is the responsible reporting entity. If the insurer payment reimburses the insured, then the insured is the responsible reporting entity. So you often hear in the context of Section 111, a simplified rule, which is that the payer reports. So the entity who actually pays the injured claimant is the entity who reports. And that is also true in the context of fronting policies. With fronting policies, it's the insurer, you know, the idea here is that the insurer will not ultimately retain any risk under the insurance policy. It is the expectation of both the insured and the insurer that the insured will retain the ultimate risk. So here the same rule applies. Where the insured pays the claim, it is the insured who is the responsible reporting entity. So while applicability of Section 111 reporting is really anchored in having an obligation to compensate personal injury claims, when you're looking at the nuts and bolts of who actually reports in many circumstances, what you're looking at is who's actually cutting the check to the injured party. However, if you're looking at an example of multiple defendants, the circumstance looks a little different. The key factor is the obligation to pay, again, but not the payment itself. So having one defendant's insurer pay the total settlement does not anoint that insurer the responsible reporting entity for all defendants. So in this circumstance, duplicative reporting is required. Each defendant's insurer reports its proportionate share, unless there's joint and several liability, and then each reports the total amount. So in case some of you have been wondering how Section 111 applies to foreign insurers, we're going to just talk about that for a second and start with CMS defines a foreign insurer as an insurer without a US tax ID number or a US address. So this next slide that's on the screen is Medicare's basis for enforcing Section 111 against foreign insurers. And I'm not entirely sure it holds water from a personal jurisdiction analysis, but I would say that as a general matter, if you're underwriting risks that there's a reasonable expectation will reach the US, then there's a pretty good chance that Section 111 applies. Of course, enforcement of Section 111 is a separate matter, but you know, an insurance contract that reaches into the United States has a high likelihood of triggering Section 111. Another issue that affects foreign insurers is privacy regulations, which are typically more stringent than in the US. Medicare's position is that there can be no privacy data violation because the Medicare beneficiary has a duty to cooperate with the Medicare's efforts to collect its conditional payments. Medicare cites as support for this statement two regulations that don't actually apply to the Section 111 process and are really related to the larger Medicare program vis-a-vis the beneficiary herself. This issue, there's no other way to say it, this issue is problematic because those regulations don't speak to the insurer's duties and they certainly don't speak to the insurer's duties under its own home country's law. And making the issue more problematic is that Medicare requires the market to use the personally identifying information of every US personal injury claimant to determine whether she's Medicare eligible in the first instance. Okay, now we're going to go through what must be reported. In actually submitting the Section 111 report, it's going to be your third-party submission agent or your defense counsel who will handle making sure that all the data points are covered, making sure that you get all of this information from the beneficiary or her attorney. But here are the basics, just so you have an idea. They're broken down really into plaintiff information, claim information, and plan information. And these next few slides are I just wanted to give you guys a context of this is what is actually, these are screenshots from the third-party submission agent website. So you can see this is when you're starting a new claim, the first information you give is insurer information. The RRE number is a discrete number that Medicare assigns to each liability insurer who has registered with it. And then you also give, of course, some information about the injured party. This is the information Medicare needs to tell you whether the individual you're dealing with is a Medicare beneficiary. That's first, last name, gender, date of birth, and social security number. The social security number can be the last 5 digits of the social, doesn't have to be the full number. Or you can use the Medicare ID. Of course, if you have a Medicare ID, there's a pretty good chance that she's Medicare beneficiary, but that's the information that's needed in the first instance. And then once you know you're dealing with a Medicare beneficiary, this is the information that would populate the actual Section 111 report. You can do this one of 2 ways. You can either start populating these data points as you go along and as you get the information, because the Section 111 report will not actually be submitted to Medicare until there is a settlement, until there is an obligation to pay. But up until that point, as you get certain data points, you can start filling it in. So the date of incident and the state of venue. The state of venue is typically the jurisdiction whose law applies. So if, for example, you're in New York State court, it would be New York. But if you're in federal court, the jurisdiction, or sorry, the venue is US. Again, this is now more information about the claimant. You are to give her injured party representative information. That's her attorney. Some of this information is, what is the phrase Medicare uses? I think it's optional. Let me see. Optionally mandatory or mandatory optional, something like that. Meaning, if you give the information, then you've just taken on a responsibility to give it accurately, but you don't have to give it. And that's the accuracy of the information you give is going to come up in a little bit when we talk about what triggers fines or what may trigger fines. The next slide, this is information about the settlement itself. So you give the date of the settlement. TPOC is total payment obligation to the claimant. You give the amount and you give the date. In a liability insurance context, 99 times out of 100, there will be one TPOC amount and one TPOC date, and that'll be it. There are some circumstances in which you might have more than one TPOC amount if you're giving advanced payments. But typically speaking, you give the amount of the settlement and then the date that you've taken on the obligation to pay. And then there's information about the plan itself, as well as the injury data. So, Medicare needs to know what the liability payment went to so that it can calculate its conditional payments. If a Medicare beneficiary gets all of her health insurance through Medicare, then she might be getting, care for her wrist, which wasn't an issue with her hot tea burns. So Medicare wants to make sure that it's not including in its lien medical care covered by taking care of the plaintiff's wrist. And then what happens once you submit the Section 111 report is that Medicare gives a response and lets you know whether the Section 111 was reported, if it was accepted, And if it was accepted, whether there are any errors in it. And you get then an opportunity to correct those errors. So this is what that would look like if there are errors in the report. And again, we're going to talk about that and why it's important in a little bit. So next, next we're going to go through best practices for Section 111 and personal injury settlements. So most importantly, you must obtain the information necessary to determine whether your plaintiff is Medicare eligible at the very outset of every US personal injury claim that you handle. The screenshot here is a form that Medicare had published very early on in the Section 111 process as being the form that insurers should rely on to obtain the information we need. I don't use it anymore. I don't think it's a very good form because it says, you know, if you're Medicare eligible, please give this personal information. If you're not, then just sign and date. But Medicare has made specific that each insurer is required to determine the Medicare eligibility of every claimant. So we need all this information, whether she's a beneficiary or not, because we have to verify vis-a-vis Medicare whether she receives benefits. So if you have a defense counsel, then your defense counsel should obtain this information as early in the claims process as possible and let you know whether you're dealing with a Medicare beneficiary, because it can change the nature of your settlement negotiations. As I said, Medicare is very specific that each responsible reporting entity must independently verify Medicare eligibility for every claimant. You are not covered by taking the plaintiff's word for it. If the claimant or the plaintiff is not Medicare eligible, then what you want to do is reconfirm eligibility status at the time of the settlement. And then you want to include appropriate language in the general release, which really is 2 clauses, just making sure that the plaintiff signs off on giving her consent to release personally identifying information, and also defense and indemnity arising out of any misinformation or non-cooperation in our attempt to comply with Section 111. If your plaintiff is Medicare eligible, then the next point at which you need to concern yourself with Section 111 is during settlement discussions. And as we saw with the 11th Circuit decision that we went through earlier, it's imperative that Medicare's interests are protected in the settlement agreement itself. So what does that mean? First, it must be part of your negotiations that the settlement funds are not dispersed until we have received a notice from Medicare advising the amount of the lien. And second, Medicare is paid directly by us. This can be done in 2 ways, either by cutting a check to Medicare directly and then dispersing the remainder of the settlement funds to the plaintiff, or by including both Medicare and the plaintiff as payees on the settlement check and letting those 2 parties hash out how much Medicare is entitled to. The reason that might be a negotiation, and it's a negotiation that is typically handled between the beneficiary and Medicare herself, is that Medicare is, of course, in every position to negotiate the lien, as with any lien. Additionally, you're going to want to consider whether to structure the settlement with a Medicare set-aside, which is really nothing more than earmarking a certain portion of the proceeds as accounting for future medical expenses. Medicare has given guidance that it considers a set-aside an essential component of complying with the Medicare Secondary Payer Act if the settlement is $250,000 or more, and there is a reasonable expectation that settlement will pay for future medical costs that Medicare would otherwise cover. And then, of course, following the settlement agreement, you're going to submit a Section 111 report. So again, if you're going to want to memorialize the terms of those settlement details in the general release. And that really, in a nutshell, is what your obligations are under Section 111.
Alison, just before you move on to the NPRM, I just wanted to say we have just a little less than 10 minutes for the remainder of your section.
Okay, great. Thanks.
Thank you.
Okay, so now we're going to go through a notice of proposed rulemaking that CMS issued, and now I'm going to explain what that means. So in February of 2020, Medicare issued a notice of proposed rulemaking, which essentially gives the public notice as to what it intends to enact for final regulations pertaining to Section 111. So as I mentioned earlier, it's really these regulations where we're going to get the very nuts and bolts of how to comply with Section 111, because we can't find that in the statute. It's not there, right? The notice is a necessary precursor for CMS to begin enforcing the statute in earnest, and by the way, collecting fines. So as an administrative agency, meaning a function of the US executive branch appointed by the president, the regulations issued by CMS and codified in the US Code have to comply with the processes set forth in the Administrative Procedures Act to have the force of law. Specifically, Medicare has to give the public and all stakeholders an opportunity to comment on its proposed regulations, and then Medicare has to consider those comments and account to them before it issues the final regulations. I also want to take a moment here to manage expectations about when we're going to see final regulations. Just last month, on February 22nd, Medicare published a notice extending the timeline to publish the final rule by yet another year. So we have a little longer to wait. Okay, so now we're going to go through what the notice of proposed rulemaking says and what we might see in the final regulations. There are really 3 scenarios of non-compliance that will trigger fines. The first is non-reporting altogether, which seems obvious. And as I said, the penalty is $1,000 per day per claim. The second is not likely something that this group is going to encounter, and that's if the Section 111 report contradicts information that is later provided to CMS. This largely would deal with what's called ongoing responsibility for medicals. The third is the most likely scenario for us, and that's if the insurer submits a report timely, but with errors. Enough of those errors over a 2-year period will incur fines by the insurer on a sort of step-by-step basis. CMS has said that it will only consider, quote, significant errors, such as inaccuracies to a Medicare beneficiary's last name or date of birth in the calculation of the error rate. We don't have any more information than that as to what is going to amount to a significant error. There are safe harbors, which is that the insurer can rely on its good faith efforts that are well documented at obtaining the necessary information. And if it can demonstrate and prove with documentation those good faith efforts, then it's going to be off the hook for not being able to give accurate or full information. Most important, perhaps, is that the final rule has made clear, which is the law in any event, but has made clear that penalties will be prospective only. So anything that's happened up to now and anything that happens until the final regulations are published will not be subject to fines by the liability market. And so I'm now going to turn it over to Fiona in just a second, but I'll just give a little bit of background to the rulemaking process, which is to say that prior to the February 2020 notice of proposed rulemaking, Medicare had published an advanced notice of proposed rulemaking, which is subject to the same public comment requirements. And the IUA submitted a comment to that advanced notice back in 2013 calling for lead-only reporting. And because, as I mentioned earlier, Medicare must account to Congress for how it deals with each of these comments, the most recent notice included a response to the IUA's comment about the inefficiencies of duplicative reporting by a subscription market. Medicare's comment was essentially, Medicare's response was essentially that CMS doesn't have the authority to make an exception to the definition of who's an RRE. And under the plain reading of the statute, under a subscription market, all co-insurers would be an RRE for the same claim. So it seemed like we weren't going to be successful, but now I'll let Fiona address. I'm going to sort of stop sharing my screen here and let Fiona address the most recent lobbying efforts before CMS by the IUA in achieving our goal.
That's great. Thanks very much for that, Alison. So as Alison said, we were facing something of a brick wall, despite our many attempts via or through the IUA and with CNF to actually try and engage with CMS in a way that we could actually come up with a practical solution for the subscription market. We carried on our efforts via Alison, and Tom, and that commitment eventually paid off in us being able to have a discussion with CMS. And I think having the opportunity to have that face-to-face, well, via Teams meeting and explain the position of the subscription policies, we finally sort of managed to break through and get them to understand how the policies worked and where we were coming from and what we were all trying to achieve. So we received confirmation from them back in January, which Alison had put up on one of her slides previously, whereby CMS confirmed that we could have lead-only reporting for subscription policies. So this now will cover all markets who are on the subscription risk, not just Lloyd's, who had previously negotiated their own deal with CMS with regards to lead-only reporting. So a fantastic result after many years of trying. So we were all very pleased with that, and hopefully this will allow for a much easier and simplified reporting going forwards. We have been advised also by CMS that the user guide that Alison referred to previously will be updated in the future, albeit that doesn't appear to be happening with any great degree of immediacy. But that will, but they have assured us that the email that they have sent we can rely on in the interim.
See, I wondered if you were surprised, because I think I was a little that during our conversation, the representatives from CMS, they had expressed their own frustration at duplicative reporting, and I think that was something. It was nice to hear how positive they were actually, I think, about trying to get to a better position.
Yeah, I think there'd been quite a sort of a great deal of confusion regarding the sort of multiple reporting that they were receiving, and they were telling sort of certain kind of reporting entities not to do multiple reporting, others were carrying on. So I think now that we've actually got some concrete guidance from them, it's definitely more positive.
Yeah, you know, I'll just say it was nice to see the law actually work in this context. You know, this is the point of the notice and comment period, you know, for an administrative agency to publish draft regulations and then receive comments from stakeholders about how those regulations would affect industry. And then the administrative agency is to really digest that and take into consideration, are those regulations too onerous for, you know, the goal that is trying to be achieved by the statute? And this was a great example of Medicare realizing this particular aspect is really not necessary for Medicare to get what it wants. So it was a nice result. It was a nice result after a lot of hard work by the IUA.
Indeed, and yourself, we should mention here, Alison, for sure. It was definitely a collaborative effort, which was fantastic. So I just wanted to draw attention again to the Q&A function and encourage people to ask questions, because otherwise you'll probably just be listening to me asking questions for a little while, and ideally we would like you to contribute where possible. So Alison, just an initial point that came to mind for me, and it's not something we've had the opportunity to speak about. Have you managed to receive any feedback from any of the US domestic insurers? I'm sure that you made them fully aware of the result. I wondered if you'd received anything back thus far. I
think, you know, the same elation that is occurring across the pond. You know, we're all very excited to not have to deal with the worry about the following market to report. You know, the domestic market was in a slightly different position in that it was already doing lead reporting and just sort of, you know, with a wish and a prayer, hoping that Medicare would, you know, would say okay to that. So practically speaking, it didn't change their process, but I think it gives everybody a great deal of comfort. Yeah, it certainly does. So just delving into the practical realities of what this change means, because I think this has been quite a big question
for some of our members in actually downing tools and relying on a lead to undertake this reporting. So one of the biggest issues that will often be discussed is, of course, the concept of fines and the fact that there is this potential to be fined. So there are probably two angles. One is, if a lead is going to be reporting now on behalf of subscribing insurers, can that lead be given the confidence that they won't be subject to fines on behalf of subscribing insurers, i.e. we know that lead could be fined if they fail to report. However, could they be fined more than once in respect of those subscribing markets? And then equally, as a follower, should a follower who is now down tools be comfortable in that they cannot be responsible for any fines if the lead failed to report? So I think they're the two key areas that it'd be great to hear your initial thoughts on.
Yeah, sure. I mean, as a first matter, I want to say that Section 111 and this concept of lead-only reporting has just happened. I can't even say it's still developing, right? Because it's just occurred. So how it's going to work and the many different, idiosyncratic circumstances in which we might wonder, well, who is the lead in that context? Or, who's really responsible for lead-only reporting? Some of the answers there are, we don't quite know yet, right? We'll have to see. This is, as with any law, it develops and it's tested, and so we'll see. But for now, what we have is this email from CMS, which, as I said before, is something that you can rely on. It is something that I could cite to a judge to say we relied upon this policy guidance given to us by Medicare. And in that email, it states very specifically that CMS will treat the lead RRE as the sole RRE for all applicable reporting, recovery, and benefits coordination requirements that presently exist, regardless of any other co-insurers that may have a subscription arrangement or similar contract with the lead insurer. So, I mean, I don't see another interpretation to that other than CMS really intends to fine only one entity for non-compliance, and that would be the lead insurer.
That's very valuable, and I'm sure gives some comfort to people that may have had that question in mind. So I can see a question has just popped up via the Q&A function. So thank you to whoever has posed this one. So the question, Alison, is, if we lead for an ILU market, but the Lloyd's market is the overall lead, or vice versa, do we still need to report? So I guess here we're starting to weigh out that potential to have dual stamps represented, i.e., a Lloyd's and then a company market presence. So perhaps, Alison, if we go to you first, and we'll see if Fiona wanted to add in on that one.
Yeah, I think we can expect that the overall lead is who CMS is going to consider the lead RRE. I mean, you could imagine in the federal regulations, once we finally get them, Medicare is not going to account for the particular markets within one policy, the ILU, Lloyd's lead. I mean, it's going to state in there for a subscription policy, the lead RRE, given these particular responsibilities, will be the sole entity that Medicare considers to be the responsible reporting entity.
Yeah, I mean, I think it is in the majority of policies, in all policies, it should be very apparent who the overall slip leader is. And it is that individual or that individual organization who is now going to be the designated RRE.
Yep, agreed. Thank you, Bea, and thanks, Alison. We do have another question, and it is a very interesting area to consider. So the question is that a number of policies that are provided by this particular individual are contracts of reinsurance, and they have claims control with the leading reinsurer. So the question is, if the leading reinsurer notifies the CMS, does the cedant have to notify for their share that is not on the reinsurance placement? So this may have been a question that you've come across already, Alison, but it'd be interesting to hear if you do have any views, or perhaps if this is an area that we need to explore in a little bit more detail.
You know, I think that this question has come from Paul, and I know, Paul, I owe you a specific response on this question. This is a difficult area that I'm not quite sure of the answer. This is one of those circumstances where I would say, you know, we got a very clear-cut response from CMS, and some of the idiosyncrasies, particularly in the context of aviation, may not fit well with the lead-only reporting rule. So to be honest, I'm not quite sure. I would have to say that sort of the simplest explanation is the one Medicare would want. I don't think it wants duplicative reporting. So wherever we can ascertain an obvious overall lead insurer who's responsible to pay on the claim, that's who we should consider to be the RRE.
Indeed, and I guess one particular point that comes to mind here, Alison, and I totally agree, it's certainly a complex area, and one that I think we should consider perhaps as an IUA claims community as well, to pull some thought, is actually the importance of communication, because this will only become a challenge in the event that there isn't communication between the various participants on a particular policy, including if it's a reinsurance. And in that event, somebody is looking at somebody else waiting for them to report, and vice versa, and then the report isn't made. I imagine that so long as there is a good communication structure in place, somebody will take responsibility, and CMS will receive the report that they very clearly wish to receive. And as we know, that's the most important element here. I don't know how that's, yeah, go ahead, Fee.
Yeah, I mean, I think, you know, that will be down to, I think, primarily communication between the policy lead, the slip lead, and the nominated service provider, or whoever's representing the insured and insurers in respect of a claim. So taking Alison's claim example that she was making earlier with regards to the lady who had the unfortunate tea spillage on the flight, you know, there will be a discussion between the leader and Alison to say, okay, this is a US citizen, we need to make the report. Alison would make her recommendations and do what she needed to do with regards to filing that report with CMS, and then that would then be noted, you know, somewhere in the report that goes out to the subscription market with their recommendations with regards to settlement, to say, you know, we have filed the necessary information with CMS. This has come back. Yes, this lady is Medicare eligible. No, she's not.
Yeah, and I think in the circumstance that was just raised, you know, I think it would look most close to the advice that's been given in the context of deductibles. From the claimant's perspective, there's only one payment. So, you know, on the back end, as between the insurers, the way that gets sort of bitten up is not really relevant to the claimant. And Medicare only wants one insurer responsible for the total claim payment. So if the lead reinsurer is who is designated with claims handling responsibility in that context, regardless of whether the cedent makes a payment, you know, that is separate from the reinsurance, I would think the lead reinsurer would report the total settlement amount.
Thank you very much, Alison. So one other area that we wanted to briefly consider was whether we as a community think that there would be value in having some specific policy language to reflect this updated change. So for example, to have some words within the claims handling agreement section of a policy to set out exactly who is going to be reporting and perhaps what will be the position if that entity doesn't report. So I don't know, Alison, if this is something that you have given any thought to yet, or perhaps this is something that we as a market representative body and then market participants perhaps need to consider in a bit more detail.
Yeah, that's a good question. I think that the answer comes sort of in two contexts. One is the legal answer, and then the other is the, you know, business or industry answer. And I'll leave Fiona to answer to the second, which I think we've spoken about a little bit with regard to communication. But as a legal matter, I don't think it matters at all. From CMS's perspective, who they're going to consider the lead insurer and whether there's compliance or not compliance is going to be totally irrespective of whatever private agreement the insurers have amongst themselves. So, I can't see it moving the needle at all, legally speaking, but that isn't to say it answers the question entirely, because there are other business considerations, which I'm sure that's more for Fiona to address.
Yeah, I think, Alison, we've spoken previously, and you said that as far as CMS is concerned, they're not interested in what arrangements are in place between the various insurers on the subscription policy. They just want the leading insurer to file the report. So I think as things stand currently, that we should be satisfied with the email and the advice that we've been given by CMS. Until such time as any further information comes out that would require sort of further attention in that area.
Okay. Well, I can see we only have a couple of minutes remaining. We haven't got any new questions on the Q&A facility. So before I wrap up, I'll just check, Alison, if there was anything that you wanted to add before we close.
No, just that it's been a pleasure working with you guys on this matter, and I'm glad that we've achieved our goals successfully. It's been many years, many years, actually. I first came to talk to the IUA about submitting a comment to the advance notice of proposed rulemaking back in 2013. But we were steadfast in our effort.
Absolutely. Yeah, I totally agree. And I can't even say that I was at IUA when all of this first started, because that was about the year before I joined. So there you go, predated even my time at IUA. It's about 8 years or so now. Fiona, was there anything that you wanted to add before we close?
Yep, no, nothing really for me to add other than to sort of again echo what Alison said. And it's been a great combined effort, and thank you both very much for all of your support in getting this finally over the line.
Okay, fantastic. Well, what I will do is just briefly confirm that we will be circulating the recording from the session along with the presentation slides. Just give us a few days to get that out to all attendees. I then need to, of course, thank you, Alison and Fiona, very kindly giving up your time to provide today's training session, which I think, as always, has been incredibly insightful, and of course is very relevant in light of the recent announcement that we had. And then lastly, to thank everyone who has kindly joined the session. I hope you found it valuable, and I'm sure that if you do have any follow-up questions for either myself, Fiona, or Alison, I would be very happy to take those. If you provide them to me, I'll probably pass them on to Alison and Fiona. It's how that usually works, but very happy to receive them and direct them onwards. So thank you all very much, and we'll look forward to the next regular training session. And of course, more details will follow in due course.
Thanks, Tom.
Thank you,
everyone.